Welcome back. We're glad you're still with us here on Morning at NTV. Time now for the Kickstarter, and we are going to be talking enhancing virtual services in the legal space. Also, the role of the judiciary as an indispensable tool in entrenching democratic societies. I'm joined by two guests I'll be introducing very shortly. Let me first give you a preamble. Institutions involved in the administration of justice collectively under the justice, law and order sector have over the years been at the forefront of justice reforms in the country through innovative mechanisms designed to close the justice gap. However, challenges do remain. E-justice solutions designed and built on people-centered access to justice models are increasingly being positioned to empower people and communities with information required to resolve legal and justice problems. Also to enable people access formal and informal services that are responsive to their legal or justice needs. And we're also going to check on the preparedness and the role of the judiciary in enhancing democracy, especially as Uganda builds up to the electoral process that will be coming to us in 2026 when the general election is held. I'm joined on site by the Public Relations Officer at the Judiciary, James Ereemye. Many thanks for joining us.
Thank you very much.
On my extreme left, Simon Peter Musangala, founder, Musangala Advocates.
Thank you.
How are you doing?
Fine, thank you.
Great. Let me begin with the honcho in our midst this morning, the spokesperson of the judiciary. I'll be putting the judiciary on the spot a little bit later, especially when it comes to how indispensable a tool it is in coming up with viable democracies, or how it can be used, especially in scenarios including extreme dictatorships, to fail democracy, or whether it's actually used in finer societies to build the same. When it comes to virtual services and how this is being entrenched in the justice, law and order sector, we've seen glimpses of it, especially when trials are being held, where some of the suspects are the facilities, prison facilities. I refer them mostly as correction facilities because people who go there must come out better persons. We've seen a bit of that happening. Could you just take us through what the state of affairs is right now so that we can have a more complete picture?
Oh, thank you very much, moderator. And I'm happy to be joined by my brother Musangala. I want to congratulate him. He has been all over the social space as being the best advocate.
No doubt.
I bring greetings to our viewers from the Judiciary, the Honorable Chief Justice and top management. And I'm happy to come and talk about this very important topic about virtual spaces within the legal industry. Of course, our people should know that we are in the now of the age of the fourth industrial revolution, and it's therefore important that we as part of government, we should embrace e-governance and move into the virtual spaces. The virtual spaces have enormous advantages, and you know we are already on the journey and it is not turning back. You see, so the judiciary is mainstreaming ICT to ensure that services that are rendered in the judicial system can be on the virtual space. And with that, we have done tremendous work. We have a whole 14 years journey, okay, from when we started from the analog systems, moving to the initial virtual space of court case management systems up to today, where we now have ECMIS, the electronic court case management information systems. But along the way, we also have come up with the other interventions like the video conferencing, the one you have mentioned, that you see people, okay, trials, and we are in that digital space. And all of that is trying to enhance access to justice and also improve on lead times, including avoiding the unnecessary costs, okay, that come with the people having to be physically in the court. And you know, COVID was a game changer here. COVID, we did not, actually when COVID came in, we did not know that actually we shall even be able to transact in a business. And this was a serious turning point, both in the institution, but also in government, okay? That the government could not be at a standstill because COVID SOPs, you can imagine, we were stay home, do everything home, and nothing goes on. But there were those critical services that could not be closed. That's right. And legal services, including judicial administration, could not be closed. Okay. And you can see we opened up that space, and we are moving the right direction. We only need support from our strategic partners and government to ensure we move ahead.
Yeah, I know the conversation, especially between the bar and the bench, have been ongoing with the view that some of the pain points that may exist are addressed. But Advocate Musangala, what do you make of the progress or the trajectory that we have seen over the years, and how does it translate for the average Ugandan who is seeking justice to be able to notice right away that I can, for example, go to the courts, and because of these virtual services or improvements that have been rolled out, I stand a greater chance to justice faster and more effectively than was the case before the advent of technology?
Thank you very much, Mr. Moderator, for this opportunity. To begin with, I must congratulate the judiciary upon the steps they are taking to ensure that we move from analog to technological advancement. That's right. As the PRO has stated, they introduced ECMIS as a form of ensuring that work is eased, filing of court documents is eased. The only challenge that we have found, or that the ordinary litigant is most likely to face to begin with, it being a new technology, it is still limited. Its accessibility is limited to only a few areas in Kampala, and then of course maybe Luwero and Jinja, and a few other areas. What this means with its introduction, it does not mean that the judiciary is going to move away from limelight, or it is not an automatic eradication of laziness, you know, from the part of the judicial officers. That now that we have introduced the ECMIS, everything is going to be, you know, right. First of all, the network in this country is a problem in terms of whether the data connection. And ECMIS purely works on network. Once the network is down, then you should know that there is no business that is going to be transacted. You will file your documents, yes. You will not even be able to upload your documents. So whereas the judiciary is moving in the right direction, there is a need to improve cable network, maybe countrywide, to ensure that some of these services are reached even to the ordinary wananchi. For example, in Budaka, Palisa, Kamuli, Mbarara, and all these other places. In doing so, we will have the time to smile about the technology. But as of now, it is still moving at a snail's pace. Beneficial to only less than, I would say less than 5% of the country that is benefiting out of it.
Allow me to stay with you on this and use what you say, the 5% sample space in the execution of the technologies that have been rolled out. What is the net value, especially within that sample space, so that we can have an idea if we are able as a country to manage to take it across the entire country, how it will transform? What is the net value within the space in which these changes are occurring?
I'm sure the PRO would be able to answer that question, but
no, he would be giving me an overly positive picture.
The ultimate is, does the judiciary have capacity? The way as we are speaking of today, does it have the capacity to transform or move this technology to every Ugandan? My answer is no. Why? There is inadequate funding. All what the judiciary is doing are trials, and they are just trials. I can call them trials and tribulations of Brother Jero. They are just trying out to do something to show that actually something is being done. But if we are serious about technological advancement, a rollout
is the backbone infrastructure.
Yes, we must begin with a backbone infrastructure that is able to maintain the technology that is being introduced. The ultimate is the funding. And I don't think in my heart of hearts the judiciary has the funding to take on this. First of all, we are having a judiciary that is struggling with the staff. It is still understaffed. You are having a judiciary in terms of magistrates. You are having a judiciary that is understaffed in terms of judges, both at the High Court, the Court of Appeal, and the Supreme Court. So the judiciary basically has a very, very big challenge. I don't know whether it is an issue of administration in terms of the judiciary, that there is poor planning, because if the government is really funding the judiciary, of course, we must appreciate that something is being done. And I must congratulate the judiciary. For the first time, we have had a government program or a program initiated by the judiciary that has worked out. For example, the construction of both the Supreme Court and the Court of Appeal.
Within the same space.
Within the same space. And this was on record time. So we must commend them in that respect. Now, it is time to see how they are going to help. Of course, that basically, to a large extent, helps the judicial officers to be comfortable in as far as administering justice is concerned. But the question is, how is the ordinary Ugandan going to benefit from that infrastructure, which is placed in Kampala?
All right. I want to throw that for you to simply submit.
Yes, of course, by and large, of course, I want to agree with the submissions of my brother Musangala in as far as challenges are concerned. In every government or economy, those challenges are there. But what is the point here? Our point is that we are in the Industrial Revolution, the fourth. And soon AI is going to take up our space. And if AI is going to take our space, we are not going to sit back, okay, and wait for this takeover, and we are not prepared at all. So this is preparedness, even amidst the meager resources that are coming. And we are very grateful to the government of Uganda, particularly His Excellency the President. He has categorically made it a point that the judiciary shall have to be supported in the area of ICT. And that transformation agenda is key in our operations. And much as it's true, we have limited internet in some places, yes, and the government is aware, and we have had discussions and conversations in this area. We are in touch with the Minister of ICT, we are in touch with the NITAU, okay, which is responsible for all these things. And all this information is available. And we are working within the available space to ensure that, yes, we take optimum use of it. And so I want to allay the fears of my brother that, yes, as we have this limited internet, let us use the available space we have. Because, you know, administration of justice continuously improves every other day with all these emerging technologies. And as you hear, we are using this available space in terms of addressing, you talked about that they are going to be lazy. No, we are not going to be lazy. There is no laziness. In fact, if you want to see how now busy, okay, the courts are, where we have only even ICMIS alone, you will really be surprised how our judicial officers and staff have really taken up the challenge. We are rolling out to so many other places. Just yesterday, on Tuesday, we were in Jinja, and we were, the Honorable Principal Judge was launching the video conferencing facility, which links the court with the prison. And all of that is still virtual space, okay, trying to, you know. So where we have that internet, which he recognizes, we want to use that internet effectively. Okay, so that services to our people are very good. Poor planning, it's not about poor planning, but it is planning within the available resources. Okay.
Which again zeroes down to the fact that he says funding is the problem at the end of it.
You know, but by and large, we cannot demand for what is not available. And we want Ugandans to support government, to support the judiciary, even within those limited resources, because it would be very bad also for us to come up with these virtual spaces, and then the public, the lawyers don't, come on board. We have had those challenges when ICMIS was brought on board. The first people who had issues to try to resist that technological advancement were our brothers, the lawyers, because you see, we were changing the landscape. We were changing the landscape, but I'm very happy. As we speak now, they are on board. They have appreciated the effectiveness, the efficiency, and all other advantages that have come with, including the most important and the bad thing called corruption. The person-to-person interaction has been reduced where ICMIS is.
We shall be looking at how exactly technology is helping, for example, deal with the corrupt tendencies. But
allow me also appreciate him for appreciating government and the judiciary. Those comments, no, that's not that he rarely does so, but those comments are very good. Yes, for our viewers, know that yes, we are not really doing badly.
That's right.
Yes.
Maybe Mr. Higen, before you come in here, he has said lawyers try to challenge ICMIS. ICMIS is a new technology.
Yeah, sure.
To date, lawyers have not stopped challenging ICMIS because of the challenges they find in its applicability. One, you cannot do any rectification on ICMIS. As long as documents are uploaded, you have no room to edit or to do an amendment. That's one of the challenges.
By the time you upload, you have...
I will give him an example. I will give you an example. You have another system of OBRS, the one for URSB.
Yes.
These are all government entities.
That's right.
With URSB, if you accidentally upload a resolution which are not supposed, you have room to edit and put another one. We are still in the mechanical way of lawyers, that lawyers don't make mistakes. We are human. So we should have a system that is accommodative, that can allow a change. The other challenge is, if you are to go, for example, if you are to use the system of URSB, you can actually initiate payment, and then it automatically comes to your phone. What ICMIS does is only to give you a PRN, and then you have to move on. So I think the judiciary must be able to benchmark.
PRA being?
A PRN meaning a payment registration number that you used to pay the fees.
That's right.
That it becomes time consuming because technology is intended to ease the time spent on doing something.
The whole value of technology and digital innovations is to do things in real time.
Yeah, but one thing I want to do a quick response here is that I think what my brother is saying is that is a training need. Our lawyers, and we have tried to do training, just budgetary constraints. We have tried to do training to advocates, including the general public, because the general public are the users of this interface.
That's right.
But it is about training. The system has all of those features. It first gives you the draft environment where you can still upload those documents, but in a draft form.
In a draft form.
Before finally uploading them for purposes of registration. Now, that draft environment, clearly we need to continue training our users so that they know that if there's a mistake in the draft environment, you are able to retrieve and correct, etc. Even after you have put there, and then there is a notification placed to the registrar. The registrar has capacity to equally allow you to do those other things. Then, of course, he's talking about what we are doing as integration, with other government agencies to ensure that they get those notifications. That integration is on. We have several agencies that we are working on, including URSB, URA, NIRA, and so many others, such that you see in real time when you need information, that information can be sourced and accessed at
by
all
any one
points.
Of those agencies.
Yes, and that's the purpose of the electronic system here.
Okay, so let me look at this from the point of view of the advocates and how easy this transformative technologies are intended to make your work more effective. What is the onboarding strategy that you have? Especially, he talks about the fact that trainings are going to be conducted or are ongoing.
We have even
within the firms and within the practicing environment. How are you onboarding technology? I see key players in legal tech, including Barefoot Law, Legal Tech Club, Legal Hub Uganda, and the Hague Institute for the Innovation of Law. These must be driving some of these initiatives. But for private law firms, how is the onboarding process going? Because you need to first be able to quickly adopt in order to stay in business. It's important.
Yeah, thank you very much. Of course, I am a representation of advocacy in this country. We have an umbrella organization called the Uganda Law Society.
That's right.
The Law Society has tried its best to ensure that advocates are sensitized, and they have organized a number of seminars to ensure that we are brought on board. At Musangala Advocates, we invite you one of these days to come and check on us. We are a technology law firm.
Yeah. Wonderful.
And
Wonderful.
I'm proud to say, if we are not the biggest younger law firm, we are the biggest law firm in the country. And I have no doubt about that. Okay. Because if you have a firm of over 40 staff, then that speaks volumes.
Within the Uganda's
within
workings.
Ugandan working, and you are able to sustain them.
Okay.
So in doing so, ICT is very, very key. Availability of internet is very key. Because you are having instances whereby you don't need now to go to the library to look for cases that for judgment that has been passed.
That's right.
You have judgments online, and in doing so, for easy accessibility, you must use technology. In other words, you must have access to computers. You must equip your law firm with the computers. You must ensure that an advocate has even smartphones nowadays. We are now moving away from the so-called big computers to small gadgets that actually serve a better purpose, even compared to those
and are more user-friendly.
Yes, that are user-friendly.
That's right.
That when you are in court and you are challenged by a judicial officer who sit at the other side and say, counsel, what's that case you are submitting on? It's just a twinkle of an eye, and you'll be able to get answer from either artificial intelligence or through other network. Okay. So the law firms, basically, we have to come up to our game. As the judiciary is trying to advance, we should advance as well to ensure that we call it imparimateria. We are moving together.
The only challenge, Mr. Ereemye.
Let's first stay on that. I know the nomenclature there might get me a little bit off guard, but how do you ensure that your clients, and especially the illiterate, are on board so that you can move together? Because technology alone could be a hindrance for them to access justice. I know of incidents, for example, where the sheer design of the court and the presence of gadgets, including screens, is enough to scare the average person down in the far-flung areas in Koboko, Kotido, even Butaleja. How is this being, how are you ensuring that we have cases where people are at ease when seeking justice? Because it's important.
Thank you. To begin with, lawyers are counselors. You must have an opportunity to take through your client the process of court.
That's right.
Otherwise, you are not going to benefit from his presence. So you must take them through. You must educate them about the new developing trends, whereby we are not going to come to court. Of course, this means you must have to visit your client if he's, for example, is in custody, in a prison. You visit and take the client through, carry out an interview, guide the client on the do's and don'ts. Because with, let me say, with the virtual proceedings...
Is it that deposition?
Sorry?
What do you call it? Deposition, something like that, where you basically do a run of what they could go through when the judge is attending to their case, or it's a case of simply advising them on how to conduct themselves?
I would call it client preparation for ease of our ordinary persons.
Okay.
So once a client is prepared, you are in court at Buganda Road, you are submitting for and on his behalf, and is in Luzira. But because of the brief that you gave him a day before court came up, we are able to proceed. So that's why, whereas the judiciary is on the spot for ensuring that the technology works, the lawyers should be on more spot because they are the first testers of the technology. So we must be able to transcend this technology from ourselves to our clients. Otherwise, if we don't do that, then, and remember, our country, most of our people, not all of us are educated or learned. We still have a large number of illiterates that have not been to school. That if somebody sees a screen for the first time, he may even black out. So it is incumbent upon the legal personnel that is handling a particular case to educate the client in a bid to ensure that the client is together with us.
Okay. Before you lose the train of thought, you wanted to submit on something?
Yes, I wanted to say something about the preparedness of our court users. Court users generally, who will include advocates and the general public, because here we have the advocates who are even educated, okay, but some of them...
No, we are learned.
Okay. Yes.
All right.
Who are learned like myself.
It's okay, you have the bragging rights.
But we want to incorporate learning and education together.
That's right.
Yes, my father was a teacher, and he would always want to differentiate between being learned and being educated. But we want to move with the two together. Our brothers out there, their main concern, and which was correct, but we have advised them to improve, was that they were not having the appropriate technological equipment to match with what we are mainstreaming as government. Okay, and of course that was affecting their access to the systems and also access to justice in that respect, and that we needed, and we took deliberate steps to educate and train and also empower them to up their systems in. And I want to thank Musangala. If for him he appreciates this kind of thing, he should also share with the others that we need to catch up with the technology. Yes, we need to.
Farm, like he says.
Yes,
that is,
because how is he capable of even accessing one of our innovations like Yuli? Yuli is the platform where they can access all these cases, okay, which the judiciary uploads for them for purposes of their legal research, okay. So if you do not have appropriate technology in terms of ICT equipment, okay, then you will definitely have those challenges. And that was one of the resistance areas, that we don't have this, and so you are going to cause a hindrance to access to justice. We simply said, no, we cannot stop the movement forward, but let us advise and ask you to up the game and get onto the same page.
I'll be returning to you shortly on projections on where we can be in 10 years' time in terms of onboarding technology in the dispensation of justice. But allow me just to engage Counsel Musangala. There is the multi-layered realities of our time. As an advocate and as a law firm, you are a player, you are a user, you are a beneficiary. In terms of onboarding technologies and stuff like that. At the beneficiary level is where, for example, another person is suing you as a firm for either misusing technology or using technology the wrong way, and their case being to their disadvantage. I do not know whether the safeguards are sufficient, or lawyers and all other actors have been prepared enough to understand that away from being a player, you can be a user, but also a beneficiary. So what is the interplay like? Because WhatsApp alone has been adopted as something that can be used as evidence in courts of law. Now, in the process of interacting with your client, there are things you say that might be used against you, in some other case. Just take us through how this whole, what I can say as a convergency of tech, law, and justice reaches a point where it's very smooth for all of us?
Thank you very much. As the PRO stated, you know, we have had a lot of developments, and developments are still coming in terms of technology.
No doubt.
If you look at the Uganda, the Law Council Act, lawyers are not allowed to advertise. We are not allowed to advertise. Now that's the law.
Yeah.
When Musangala Advocates and Solicitors was formed, we took the country by the storm. We went on Facebook, created our pages on Facebook, gave all information about the firm on Facebook, went on Google, created one of the best websites with all the languages in the world, that if you want French, you just move, click, and the whole website is going to come into French.
Yeah.
The question is that advertising? That is contrary to the law? The answer
was publicity.
So depending on how you call it.
So to speak.
Now, with the advancement of technology, even the archaic laws that had been made before, without the envisagement of this technology coming to light, are coming under check.
Being tested.
Now, you have had instances whereby a conversation on WhatsApp, can you deliver for me 20 cows? It is okay. At how much? It's going to be 3 million per cow. Courts have actually held that there is actually a valid contract.
Very valid.
And this is evidence. So, with the advancement of technology, lawyers need to be akin to what is posted. Not only lawyers, but everyone, our viewers, they must be akin as to what they discuss in terms of business, in terms of sharing information. What are you sharing? The information you are sharing in a laissez-faire manner may actually be a binding contract on you.
That is right.
So in so doing, we must be very, very careful. So in doing so, whereas you are saying a contract above 1,000, 5,000 must be written.
If you're transacting business.
If you are transacting business, a contract of a specific amount must be written down and in writing and must be signed. So now with the advancement of technology, courts are saying no. Gone are the days. We can actually have a contract deduced from what the parties discussed on phone, on technology. And now these are this is the beauty and the dangers of technology at the same time. So as we descend into the arena of this kind of technology, we must be aware of its dire consequences to both lawyers and then of course the non-lawyers. So whatever you say can easily be used against you. That's what should be at your mind when you are communicating using these virtual technologies.
Is this kind of thinking apparent within government or the workings of the judiciary?
Of course, Mr. Musangala is correct that you see, with the emergence of all technologies, okay, there is need for legal reform. And I want to inform our viewers that the coming of hard technology has also required the judiciary to get back to its legal frameworks to ensure that they are enabling legal frameworks that can allow the application of those facilities in the law. Like we have so many enactments which have been done. The Chief Justice has issued so many statutory instruments and practice directions in that direction to ensure that we give effect to the operationalization of ICT in the courts. And I want also to mention that yes, those emerging issues as a result of technology have also awakened the Law Reform Commission, you see, and I'm very certain on their highest agenda is how to synchronize technology with our existing law. And a lot of discussion is going on to ensure that the archaic laws that are now going to apparently be in conflict with the current virtual space services are put in tandem.
Okay.
And so that's the direction we are going, and we want all stakeholders who really can be supportive and can add value to these law reforms to come up and we have a holistic approach to this dispensation.
Okay. Gentlemen, we are entering the final bend of our discussion, and I would like to use our final minutes to ask the fundamental question. All these improvements, these changes, innovations, how do they augur for the development and entrenchment of democratic practices? Can, for example, the people say that with the advent of these innovations, maybe leadership, democracy, and the politics of the day will be improved? Advocate Musangala, what do you make of that?
Thank you very much. As long as the judiciary has no clout, has no capacity, has no credibility to handle challenges that are before it, then the technology innovation is useless.
And democracy is threatened.
And democracy is threatened. We are moving towards the 2026 presidential, parliamentary general elections.
Yeah.
Is the judiciary ready, even with the advancement of technology? It is a question that they need to ask, and they need to answer, and let Ugandans know. With the inadequate funds they are talking about, with the inadequate technology, the technology we are talking about has not even, it is within a few courts. You are having instances where the Parliamentary Elections Act is saying cases must be handled within 6 months. You have had cases where the judiciary has had cases for more than 2 years. I will give you an example.
Even the entire duration of a term.
Of Nyanzi Sentamu versus Electoral Commission. This is a matter which was filed in 2021, and it was determined sometime in April 2023, after 2 years. So assuming this kind of case had been held in favor of the petitioner, that means the petitioner wouldn't even serve for 2 years over their term. So the judiciary must, as a cornerstone of democracy, must be able to expeditiously adjudicate these cases. But they cannot do that when they are understaffed in terms of judges. They cannot do that when they are understaffed in terms of the magistrates and the infrastructure development. Yes, of recent there has been appointments of a few magistrates and judges. The question is, how prepared are they to accommodate those they have appointed? Does the judiciary have a policy of ensuring that, let me say, judicial officers that stay far away from Kampala, Kochido, and do they have hardship allowance, let me say so? For example, URA, if you work up country, they give you hardship allowance. Are this judiciary ably remunerated? If they are not, aren't you bringing the cancer of corruption, the temptation of corruption towards them? Closer to them? So the judiciary has a hard task as we move towards the general elections.
Okay. James Ereemye will be responding very shortly, and he'll also do a wrap for this particular conversation. But there's something that I need a very specific answer to: legal reasoning and political influence in coming up with court rulings, or judges coming up with this. It's a bit of a disturbance for the average mind out there. There are rulings that are arrived at, and many see them as politically influenced rather, and not legally reasoned. You have something to say on that?
The beauty with our system is that we have systems of appeal.
Okay.
You see, in this country, the beauty is that anybody can be appointed. As long as you have legal knowledge, you can be appointed a judge. We have had people that have been RDCs, Before, we have had people that have been members of parliament. They take the Chief Justice, current Chief Justice. He was purely in government. He's now the Chief Justice. Now, if you are in opposition, if he gives a judgment that is in your favor, you will say it has been politically motivated. If he gives a judgment that is in disfavor, you will keep quiet. So I think it is about which side of the coin you fall on. Okay. However, I can't dispute that there is no political interference, you know. But that threatens the independence of the judiciary. That's right. So whereas I know the judiciary cannot work in isolation of other forms of government. These are three organs that work together: parliament, judiciary, and executive. Okay. But the ultimate is the judiciary must do their work without fear or favor. They must put the people first, because all judicial power is derived from the people and exercise the same for and on behalf of the people. And they do that without fear or favor or direction from any entity of government. Justice Ereemye, quickly respond and wrap this up for us. We have 5 minutes to go.
Thank you for that revelation. It has not come by your might, but it is by the grace of God.
By the grace of God.
Yes, no doubt. God speaks through his people, and I'm sure the fountain of honor has had. Yes, development and entrenchment of democratic governance in Uganda. One important thing I want to say is, first of all, I want to thank Mr. Musangala for his last comment on rulings and judgments, and it's very spot on. I want to thank him, and I will not dwell much on that. But we are talking about the virtual space and how it will enhance democratic governance in Uganda. First of all, there are so many reasons why judiciary is entrenching a lot in the virtual spaces. But one critical aspect, which even Mr. Musangala has talked about, was the issue of delays. Technology has been onboarded for purposes of case management, okay, and reducing lead times. You know, the manual systems have had their flaws, but with the electronic systems and virtual spaces that have so far been engineered, we see a lot of improvement in terms of effectiveness and efficiency, and lead times reduced fundamentally. And we have in the electronic systems of virtual spaces a capacity to have what we call bring up systems, a system which will keep prompting you and informing you about a position that you ought to take within a specific case category and or position of that case. He has mentioned delays in electoral petitions, for instance. That is an issue of the past. The last election alone, we really returned a record time, 6 months period, and I want the public to be happy with that, and we are set to ensuring that we keep that legal framework and position to ensure that election petitions are done within that. And even when those which went on appeal, they were equally handled in record time, and that is something we need to be proud of, and we shall ensure we continue doing that to ensure that electoral processes and democracy is achieved in our country. It is about the delays, nothing else. We are at the end where we receive cases, okay, and then in those cases we make pronouncements, okay, which pronouncements become precedents and authority on what can inform electoral reforms. Okay. Money given to us, yes, we have been given money. It's true, the money is not adequate. It's not enough to cater for everything, but within that envelope, resource envelope, we are managing what we can do best. And we want to thank government for what they have given us, and still continue asking government to support us. You know, government, His Excellency promised that we shall be having an incremental budget every financial year. Then, of course, if we can achieve that, okay, this financial year, specifically the president emphasized, he added us more funds to what we got last financial year for purposes of ICT.
The government added you funds, not the president.
of course, if the president is positive about this, and we know this thing. When the president appreciates what you're doing,
that's right,
he can influence giving you the resources, and we want to thank that, and we cannot shy about thanking him on this. And so, but what we have, we are optimally putting it to the right areas, including that. Yes, infrastructure development, we have those challenges. But within what we have, including ensuring that networks are put in places so that ICT is effective in all these places, is what we are doing. Manpower, we have been blessed with a number of appointments. Even now, you see Mr. Musangala, the cry over the delays in the Court of Appeal is being answered. The Judicial Service Commission is recruiting.
You should interest Mr. Musangala to come to your
so of course, he talked about hardship allowances. I want to inform him that within our meager resources, we pay hardship allowances to our judicial officers in the hard-to-reach areas. We have had the opportunity, government has supported us, even amidst these challenges, to allow us have transport for these officers. And you can see that's the good direction. I am so happy that we are on the same page, and we need actually support. Collaboration. We need these conversations positively. Tomorrow we have a bar bench the forum, so if Mr. Musangala can even come and share with us these very good insights,
no doubt
we shall be helpful.
Justice James Ereemye, many thanks for
once again
submission.
Thank you very much for that.
Of course, it has emboldened our understanding of how virtual services are being entrenched within the judiciary. Many thanks for making time. And Advocate Musangala, many thanks too, and for the tech improvements and digital innovations in law practice that are going on at the firm. No doubt, congratulations. That will do it for our Kickstarter discussion. I hope wherever you are, you now understand that, well, technology is improving the dispensation of justice. May you receive justice swiftly, effectively,